Welcome to Crime Time, Inc. My name is Alex, and I'm your host today for episode 21 of our Charles Manson series. When most people think of a murder trial, they imagine the courtroom drama, witnesses, cross-examinations, and a jury deciding guilt or innocence. But in the USA, before all of that, there's a quieter and often overlooked step in the process, the grand jury. In the Charles Manson case, this step played a critical role in getting the charges off the ground. After Susan Atkins, one of Manson's followers, confessed to her role in the murders while in jail, prosecutors acted fast. They feared that if her cooperation became public too soon, it could tip off the rest of the Manson family, giving them time to disappear, destroy evidence, or intimidate witnesses. So instead of holding a public preliminary hearing, they went to a grand jury. A grand jury is made up of regular citizens, usually between 16 and 23 people, who meet in secret. Their job isn't to decide if someone's guilty or innocent. It's simply to decide, is there enough evidence to bring formal charges and take this person to trial? The prosecutor presents witnesses, evidence, and testimony, and the jury listens behind closed doors. There's no judge and usually no defense lawyers either. In this case, the star witness was Susan Atkins herself. On December 5, 1969, after hearing her testimony and reviewing the evidence, the grand jury handed down indictments, formal charges, against Manson and several of his followers for multiple counts of murder and conspiracy to commit murder. And that indictment is what officially launched the criminal case. Only after the grand jury finished its work did the rest of the legal process begin. The arraignment, which is when the accused are formally told of the charges, and then the pre-trial or discovery phase where the prosecution and defense start the sharing of evidence, preparing motions, etc., and the long road to one of the most infamous trials in American history. So while the trial made headlines, the real beginning of justice for the victims quietly started in a secret room, with a jury the public never saw. But now the proceedings for the main trial can begin. July 24, 1970. They walked into the courtroom that day thinking it would be just another jury selection. But this was no ordinary trial. This was a case that would shock the nation, a moment when 12 ordinary citizens would be asked to confront the face of pure evil. The year was 1970, and the Hall of Justice in Los Angeles was about to become the epicenter of one of the most infamous murder trials in American history. As the first panel of 60 prospective jurors filed into Department 104, something changed in the atmosphere. Curiosity morphed into shock. One man gasped loud enough for others to hear, "My God, it's the Manson trial!" Charles Manson sat there, his piercing eyes scanning the potential jurors. This was a man who had orchestrated some of the most brutal murders in recent memory, yet he wasn't the one who had physically committed the killings. That was the twisted genius of Manson. He didn't need to get his hands dirty. He had others do his bidding.
Silence in the court!
The presiding judge, Charles Older, had already received multiple threats. Security was tight, a driver bodyguard assigned round-the-clock protection at his residence. The stakes were impossibly high. This wasn't just about solving a murder. This was about understanding how a man could manipulate others into committing unspeakable acts. Prosecutor Vincent Bugliosi knew the case would be complex. The prosecution's entire strategy hinged on a legal concept called vicarious liability in conspiracy. In simple terms, even if Manson wasn't physically present during the murders, he could be held responsible if the killings were committed to further the goals of his conspiracy. But selecting a jury would be a psychological chess match. Judge Older decided on complete sequestration. The jurors would be locked away from the world for what could be up to 6 months, albeit in the Ambassador Hotel. The Ambassador was once one of the most glamorous hotels in Los Angeles, especially from the 1920s to the 1950s. It hosted Hollywood stars, presidents, and foreign dignitaries. The famous Coconut Grove nightclub inside the hotel was a legendary hotspot for celebrities. The Grove was a popular location for live music, with concerts by Frank Sinatra, Lena Horne, Peggy Lee, and Nat King Cole. It was the first major club to hire Harry Belafonte, and Dean Martin got his first movie deal after an appearance there. In 1958, Judy Garland recorded a live album, Garland at the Grove, in one take. Barbra Streisand was cast in Funny Girl shortly after a 3-week stint at the club. But listeners to our podcast may be familiar with the Ambassador Hotel for another far more infamous incident. Just 2 years before, in June 1968, Senator Robert F. Kennedy was assassinated in the hotel's kitchen shortly after delivering a victory speech for the California Democratic primary. This tragic event gave the Ambassador Hotel an even more intense atmosphere, something not lost on jurors sequestered there in a nationally explosive murder trial. After Older finished the initial questioning, the attorneys began their individual examination. Patricia Krenwinkel defense attorney Paul Fitzgerald started off the questions, which were largely conversational and quite often showed no sign of prior thought. For example, have you or any member of your family ever been the unfortunate victim of a homicide? Fitzgerald asked this not once but twice before one of his fellow lawyers nudged him and suggested that if the prospective juror was a homicide victim, he wouldn't be of much use on a jury. The defense attorneys were a fractured group, constantly manipulated by Manson. When attorney Ira Reiner tried to distinguish his client, Leslie Van Houten, from the others, Manson's reaction was swift. Van Houten was instructed to try to fire Reiner, echoing similar attempts by Patricia Krenwinkel against her own attorney. Manson contended that he was already presumed guilty. Therefore, there was no need to question the jurors, since it didn't matter who was selected. Manson and the girls caused no disruptions during jury selection. However, Manson would often stare at Judge Older for literally hours. Bugliosi surmised that he had developed his incredible concentration while in prison. Older totally ignored him. One day, Manson tried it with Bugliosi. He stared right back, holding Manson's gaze until his hands started shaking. During the recess, Bugliosi slid his chair over next to Manson's and asked, "What are you trembling about, Charlie? Are you afraid of me?" "Bugliosi," he said, "you think I'm bad and I'm not." "I don't think you're all bad, Charlie. For instance, I understand you love animals." "Then you know I wouldn't hurt anyone," he said. "Hitler loved animals too, Charlie. He had a dog named Blondie, and from what I've read, Adolf was very kind to Blondie." Manson asked Bugliosi why he thought he was behind these murders. "Because both Linda and Sadie told me you were," he replied. "Now, Sadie doesn't like me, Charlie, and she thinks you're Jesus Christ, so why would she tell me this if it wasn't true?" "Sadie's just a stupid little bitch," Manson said. "You know, I only made love to her 2 or 3 times. After she had her baby and lost her shape, I couldn't have cared less about her. That's why she told that story, to get attention. I would never personally harm anyone." "Don't give me that crap, Charlie, because I won't buy it. What about lots of Papa? You put a bullet in his stomach," Bugliosi said. "Well, yeah, I shot that guy," Manson admitted. "He was going to come up to Spahn Ranch and get all of us. That was kind of in self-defense." Manson was enough of a jailhouse lawyer to know that Bugliosi couldn't use anything he told him unless he'd first informed him of his constitutional rights. Not once in this, or the numerous other conversations between the two, did Manson flatly deny that he had ordered the murders. An innocent man protests his innocence. Instead, Manson played word games. If he took the stand and did this, Bugliosi felt sure the jury would see through him. Would Manson take the stand? The general consensus was that Manson's prodigious ego, plus the opportunity to use the witness stand as a forum to expound his philosophy before the world press, would impel him to testify. But no one but Manson really knew what he would do. In private moments, Bugliosi had strange, revealing conversations with Manson. When confronted about the murders, Manson would never directly deny ordering them. Instead, he would play elaborate word games, revealing a chilling mixture of honesty and deception. One particularly telling moment came when Bugliosi challenged Manson, asking where he got the crazy idea that other people don't like to live. Manson's response? A smile. He had been challenged, and he knew it. By July 14th, after 5 intense weeks of jury selection, during which 205 people were examined and nearly 4,500 pages of transcript accumulated, a jury was finally selected. 7 men and 5 women, ranging from an electronics technician to a mortician, would decide the fate of Charles Manson and his followers. 6 backup jurors were also selected, and they too were sequestrated. Leslie Van Houten formally requested that her attorney be relieved and Ronald Hughes appointed instead. But the real question lingered. Could 12 ordinary citizens truly comprehend the darkness that had brought them together in this courtroom? During the jury selection process, 2 of Manson's family were set free. Mary Brunner was reindicted and rearrested for the Hinman murder. Her attorneys filed a writ of habeas corpus, ruling that she had fulfilled the writ and Brunner was released. The right of habeas corpus is not a right against unlawful arrest, but rather a right to be released from imprisonment after such arrest. Meanwhile, Steve Clem Grogan pleaded guilty to a grand theft auto charge stemming from the Barker raid. Van Nuys Judge Sterry Fagan heard the case. He was aware of Grogan's lengthy rap sheet. Moreover, the probation department, usually very permissive, in this case recommended that Grogan be sentenced to a year in the county jail. We also informed the judge that Clem was exceedingly dangerous and that he had not only been along on the night the LaBiancas were killed, but we also had evidence that he had beheaded Shorty Shea, said Bugliosi. Yet unbelievably, Judge Fagan gave Clem straight probation. On learning that Clem had returned to the family at Spahn Ranch, Bugliosi contacted his probation officer, asking him to revoke Clem's probation. There was more than ample cause. Among the terms of his probation were that he maintain residence at the home of his parents, seek and maintain employment, not use or possess any narcotics, not associate with known narcotics users. Moreover, he had been seen on several occasions, even photographed with a knife and a gun. His probation officer refused to act. He later admitted to LAPD that he was afraid of Clem. Though Bruce Davis had gone underground, most of the other hardcore family members were very much in evidence. Some dozen of them, including Clem and Mary, haunted the entrances and corridors of the Hall of Justice each day, where they would cast cold, accusing stares at the prosecution witnesses as they arrived to testify. The problem of their presence in the courtroom, a concern since Sandy had been found carrying a knife, was solved by Aaron Stovitz. Prospective witnesses are excluded when other witnesses are testifying. He simply subpoenaed all the known family members as prosecution witnesses, an act which raised a tremendous furor from the defense but made everyone else breathe a little easier. July 24, 1970. The air in the Los Angeles courtroom crackles, not just with the summer heat, but with a palpable, almost suffocating tension. Spectators, some queued since the bleak hours of 6 a.m., lean forward, craning their necks. They're all here for one reason, one man. And as Charles Manson is escorted in, a collective gasp ripples through the room. There, carved into his forehead, raw and bloody, is an X, a self-inflicted mark, a defiant brand. The Tate murder trial is about to begin, and its most notorious defendant has already made his opening statement, not with words, but with his own flesh. The previous night, Manson had taken a sharp object and gouged that X into his skin. His followers outside the court quickly distributed a typed message, a bizarre manifesto. "I have X'd myself from your world," it declared. "You have created the monster. My faith in me is stronger than all of your armies, governments, gas chambers. Love is my judge." Inside, the formalities began. People versus Charles Manson, Susan Atkins, Patricia Krenwinkel, and Leslie Van Houten. All parties present. The judge turns to the prosecution. "Do the people care to make an opening statement?" Vincent Bugliosi rises. "Yes, Your Honor." This is it, the moment to lay bare the horror, to outline the almost unbelievable narrative the prosecution intends to prove. He begins by summarizing the charges, naming the defendants, and then he takes the jury, and indeed the world, back to those 2 horrific nights. August 9th, 1969 at 11050 Cielo Drive and the following night at 3301 Waverly Drive, listing the names of those who never saw another dawn. Bugliosi poses the question that hangs heavy in the air, a question he knows is on everyone's mind. What kind of a diabolical mind would contemplate or conceive of these 7 murders? What kind of mind would want to have 7 human beings brutally murdered? He pauses, letting the weight of it sink in before delivering his answer. We expect the evidence at this trial to answer that question and show that defendant Charles Manson owned that diabolical mind. He paints a picture of Manson, a man who sometimes dared to call himself Jesus Christ, a vagrant wanderer, a frustrated singer-guitarist, a pseudo-philosopher. But beneath that, Bugliosi promises the evidence will unmask the truth. Charles Manson is a killer who cleverly masqueraded behind the common image of a hippie, peace-loving. The truth, Bugliosi contends, is far more sinister. The evidence will show Charles Manson to be a megalomaniac who coupled his insatiable thirst for power with an intense obsession for violent death. Bugliosi then describes Manson's family, not a loving commune, but a nomadic band of vagabonds with Manson as their unquestioned leader and overlord. He anticipates the defense, that Manson was no leader, that he never ordered a thing. Irving Kanarek, Manson's lawyer, leaps to his feet. Your Honor, he is now making an opening statement for us. The objection is overruled. Bugliosi presses on, stating the prosecution will prove Manson's dictatorial leadership, the slavish obedience of his followers, and that these 7 murders were committed at his command. This total domination, he explains, is circumstantial evidence. If they did everything else he said, why not this? The linchpin for the prosecution, Linda Kasabian. Bugliosi tells the jury she will testify, and her story will interlock with the cold, hard physical evidence, the gun, the rope, the bloody clothes. And then, Bugliosi arrives at the question that has tormented investigators and the public since the news first broke. Why? He clarifies that the prosecution doesn't have to prove motive, but when they have evidence of it, they present it. In this trial, he declares, we will offer evidence of Charles Manson's motives for ordering these 7 murders. Anyone expecting a simple motive like robbery is in for a shock. Bugliosi reveals a motive, or rather motives, as twisted and disturbing as the crimes themselves. Beyond Manson's passion for violent death and his extreme anti-establishment state of mind, there was something else, something perhaps as bizarre or perhaps even more bizarre than the murders themselves. He introduces the term helter-skelter. We'll hear Bugliosi's explanation of helter-skelter after this quick break. Manson, Bugliosi explains, was an avid follower of the Beatles, believing their lyrics were messages directed at him. Helter-skelter, a song title, became Manson's term for an apocalyptic race war. He preached that black people would rise up and annihilate the white race, all except for Manson and his chosen few. They planned to wait out this bloody chaos in a bottomless pit in the desert, a haven supposedly described in the Book of Revelation. Bugliosi outlines Manson's twisted racial views, hatred for black people, yet also for the white establishment, the pigs. And those words, pig, death to pigs, helter-skelter, rise, they weren't random graffiti. They were found daubed in the victim's blood at the crime scenes. The horrifying theory crystallizes. Manson ordered these savage murders, Bugliosi asserts, to ignite helter-skelter. He wanted it to look like black individuals had committed these atrocities against white victims. The goal? To provoke the white community into a brutal retaliation against the black community, sparking a devastating civil war. And who did Manson believe would win this war? The black man. But in Manson's warped vision, black people, supposedly inexperienced in ruling, would then have to turn over the reins of power to those whites who had survived, namely Charles Manson and his family. He would be the ultimate beneficiary of the carnage he orchestrated. Bugliosi acknowledges the sheer outlandishness of this. We intend to offer the testimony of not just one witness, but many witnesses on Manson's philosophy, he tells the jury, because the evidence will show that it is so strange and so bizarre that if you heard it only from the lips of one person, you probably would not believe it. The focus, undeniably, is on Manson. Convicting him is paramount. But what about his followers, the women in the dock? Susan Atkins, Patricia Krenwinkel, Leslie Van Houten. Bugliosi knows he's handed their lawyers a potential defense. If Manson was the all-powerful leader, were the girls less culpable? He preempts this. The evidence will show, Bugliosi continues, his voice firm, that they, along with Tex Watson, were the actual killers. He doesn't stop there. The evidence will also show that they were very willing participants, that by their overkill tactics, Rosemary LaBianca stabbed 41 times, Wojtek Frykowski stabbed 51 times, shot twice, and struck violently over the head 13 times. These defendants displayed that even apart from Charles Manson, murder ran through their own blood. He briefly touches on key evidence against the women: Atkins' confessions, Krenwinkel's fingerprint, the evidence implicating Van Houten. He then paints a timeline of the family, from its Haight-Ashbury origins in 1967 to its demise in the desolate Barker Ranch near Death Valley in 1969. Between these two dates, Bugliosi states grimly, 7 human beings and an 8.5-month baby boy fetus in the womb of Sharon Tate met their death at the hands of these members of the family. He calls the murders perhaps the most bizarre, savage, nightmarish murders in the recorded annals of crime. His promise to the jury is stark. Mr. Stovitz and I intend to prove not just beyond a reasonable doubt, but beyond all doubt that these defendants committed these murders. He concludes by urging the jury to take copious notes, quoting the Chinese proverb, "The palest ink is better than the best memory," and expressing confidence in a fair trial. Kanarek, Manson's lawyer, had interrupted 9 times with objections, all overruled. Afterwards, he demands the statement be stricken or a mistrial declared. Both denied. Paul Fitzgerald, another defense attorney, scoffs to the press, calling Bugliosi's remarks scurrilous and slanderous, and the helter-skelter motive a truly preposterous theory. Bugliosi, however, feels a quiet confidence. He suspects Fitzgerald won't even be arguing that point by the trial's end. The prosecution calls its first witness, Colonel Paul Tate, Sharon Tate's father. Military erect, his grief tightly contained, he takes the stand. Searched before entering due to rumors he'd vowed to kill Manson, he glances only briefly at the defendants. His testimony is brief, identifying photos of his daughter and the other victims. He's followed by Wilfred Parent, who breaks down seeing a photo of his murdered son, Stephen. Then Winifred Chapman, the Tate maid, details her routine, establishing a timeline before the horrors. On cross-examination, Fitzgerald immediately tries to imply impropriety, noting she'd told Bugliosi about washing a door months later, not the police. The first hint of a defense strategy to paint Bugliosi as a manipulator. William Garretson, the caretaker who claimed he heard nothing, is next. He appears sincere, if shy. Bugliosi questions him about the stereo volume. It was about medium. It wasn't very loud, Garretson replies. Bugliosi sees this as proof of Garretson's honesty. If he were lying about hearing nothing, wouldn't he claim the stereo was blasting? Fitzgerald, for his part, grills Garretson about his arrest, later even suggesting Garretson himself was involved. A desperate reach, Bugliosi thinks. For both Chapman and Garretson, Kanarek has only one question. Had they ever seen Charles Manson before court? Both say no. The next witness is Dennis Hurst. Dennis Hurst grew up in Beverly Hills during the 1950s and 60s in a family deeply connected to cycling. His great-uncle Hans Ort owned a prominent bicycle shop called Hans Ort Lightweight Bicycles, located on the southeast corner of Camden and Little Santa Monica Boulevard. This wasn't just any bike shop. It was an establishment that catered to the elite of Beverly Hills, selling high-end European racing bicycles alongside more common American brands like Schwinn. The shop was staffed by former Olympic cyclists, giving it serious credibility among enthusiasts. Being situated in the heart of Beverly Hills meant the shop regularly served Hollywood royalty. Dennis's stories about these encounters paint a vivid picture of celebrity culture in the late 1960s. Charles Bronson was a regular customer, described by Dennis as a very gruff kind of bull in a china shop kind of guy, who would bark orders and stomp out. Bronson traveled with what Dennis called a private secretary, who would follow behind, smoothing ruffled feathers and handling the actual business transactions. Perhaps the most entertaining celebrity story involves comedy legends Buddy Hackett and Don Rickles. One day, Hackett came into the shop looking to buy an expensive German tricycle as a gift for Rickles' newborn daughter. He purchased the top-of-the-line model for about $100, a considerable sum at the time, and had it wrapped with a red bow. A few weeks later, Rickles marched into the shop with the tricycle under his arm, complaining that his idiot friend had bought his baby daughter something she couldn't use for years. As Dennis's father offered to refund the purchase, Hackett coincidentally walked in through the back entrance and caught Rickles returning his gift. The two launched into an impromptu comedy routine of biting insults that had Dennis laughing so hard he had to sit down. As Dennis put it, "You would have paid money to listen to this routine at a Vegas nightclub." Dennis recalls one day Barbra Streisand tried to park her Cadillac Eldorado illegally outside the shop while she visited the bank across the road and was curtly told to move by Dennis's father. As Dennis puts it very diplomatically, she wasn't very nice. In contrast, Jimmy Durante was remembered fondly as a regular customer who lived in a modest house on Rodeo Drive and always paid with $100 bills, telling them to keep the change, even when purchases were just a couple of dollars over $100. The shop also became a hub for young Hollywood actors getting into car racing in the 1960s. James Garner, Steve McQueen, and David McCallum would park their souped-up Cooper Minis, Broncos, and Mustangs behind the shop. On August 8, 1969, Dennis's 18th birthday, a seemingly routine bicycle delivery would place him at the intersection of Hollywood history and horror. Earlier that week, on Wednesday, August 6th, Abigail Folger and Wojciech Frykowski had visited the bike shop and purchased a British Raleigh bicycle for Folger. Dennis's father had delivered the bike that evening. However, the couple contacted the store a day or two later, saying they had received the wrong color. Dennis's father arranged to exchange it, but was told the couple wouldn't be home until after 7:30 p.m. on Friday night. Since it was Dennis's birthday, and he wanted to take his girlfriend Janice to the movies, his father made a deal with him. Dennis could borrow the family van for his date if he made the bicycle exchange on his way out. Following his father's instructions, Dennis arrived at Cielo Drive around 8 p.m. He located the hidden button in the bushes that opened the electronic gate and drove in, noting that the gate automatically closed behind him without needing to drive over any pressure plate or sensor cables. Dennis parked at the garage, unloaded the correct bicycle, loaded the wrong one into the van, and then walked around to the front of the house to notify someone of the exchange. He crossed the driveway between two parked cars, went through a gate in a split-rail fence, past a wishing well, walked across the lawn and up some flagstone steps to the front porch. When Dennis rang the doorbell, he was greeted by a man he didn't recognize at the time but later identified as Jay Sebring. Dennis informed him about the bicycle exchange. They exchanged perhaps 25 to 50 words, and then Dennis left, driving back through the gate which closed automatically behind him. The next morning, Dennis heard news reports about murders at a Beverly Hills estate while driving to his girlfriend's house. When he arrived, Janice told him to call his father immediately. His father informed him that the murders had occurred at the house where Dennis had delivered the bicycle the night before. Dennis immediately insisted they should call the police to report what he knew. When Dennis called the West Los Angeles Police Department and told them he had been at the murder scene around 8 p.m. the night before, he spoke with a sergeant who said, "Yeah, I'm the right guy to talk to," and he took down his information and timeline. The officer said, "You'll be hearing from us." But Dennis never heard back from them. This is where the story takes an astonishing turn. About a month later, after returning from a California road trip with friends, Dennis's father instructed him to come straight to the bike shop. When Dennis arrived, he found two police detectives waiting to speak with him. It turned out that while Dennis was away, detectives had come to the bike shop with a receipt they'd found in a drawer at the murder scene, the receipt for Abigail Folger's bicycle purchase. They were asking Dennis's father detailed questions about Wednesday afternoon when Folger and Frykowski had visited the shop. At some point during this questioning, Dennis's father expressed his surprise. "I just find it very curious that you're asking all these questions about what I saw on Wednesday afternoon when you haven't bothered to call my son back who was there at the murder scene delivering a bicycle at around 8 p.m. that night." The detectives were stunned and almost speechless. "What?" they exclaimed. The last person to see anybody alive at the Cielo Drive murder scene had called the police the next day and told the sergeant that he had been there a few hours before the murders took place, and the message had never been passed along. The detectives immediately wanted to interview Dennis. They showed him photographs to confirm it was indeed Jay Sebring he had spoken with. Dennis's testimony would become important for establishing the timeline of events. He could testify with certainty that when he left around 8 p.m., the phone cables had not been cut. By the next morning when the maid arrived, the cables were cut and draped across the driveway, evidence that would help match striations on the cables to wire cutters found at the Spahn movie ranch. Dennis was called to testify. His direct examination by prosecutor Vincent Bugliosi was straightforward, focusing on establishing that the phone lines were intact when Dennis left the property. The cross-examination by defense attorney Irving Kanarek was considerably more challenging. Dennis described it as obstructionist, with Kanarek parsing apart every sentence. When Dennis stated that Jay Sebring had acted normal during their brief interaction, Kanarek demanded clarification on what Dennis meant by normal. Dennis recalled responding somewhat insolently, frustrated by the attorney's tactics. All the while, Charles Manson sat about 20 feet away, giving Dennis what he described as the stink eye. Dennis likened the experience to Huck Finn sitting across from Injun Joe in the courthouse. After his testimony, Dennis left the courthouse and found a newspaper box on the street. He bought a copy of the Los Angeles Times and was startled to see his own photograph on the front page above the fold. As he was looking at the paper, he heard hissing sounds and looked up to find 8 or 9 members of the Manson family across the street, heads shaved, wearing hippie clothing, pointing at his picture in the paper and then at him, giving him the evil stink eye. For Dennis, this was an unsettling moment, especially considering he was about to drive home to a somewhat secluded cul-de-sac just 2 miles from the murder scene. Dennis recalls that before the murders, Beverly Hills had seemed like an innocent paradise. He had never owned a key to his family's front door, and their cars were often left unlocked with keys in the ignition. After the murders, things changed. The family began locking their doors, and Dennis remembers paying extra attention when the dog barked. Perhaps the most chilling aspect of Dennis's story is the what-if scenario. After the movie on the night of August 8th, Dennis had initially planned to take his girlfriend to make out at a secluded spot he knew, the end of the cul-de-sac at Cielo Drive. He had even suggested it to Janice as they were driving up Benedict Canyon around midnight. Fortunately, Janice suggested they go back to her parents' home in Brentwood instead, where her father gave them some privacy in the family den. Years later, Dennis and Janice reflected on how her father's trust and hospitality might have inadvertently saved their lives by keeping them from arriving at Cielo Drive around the time the Manson family members did. By day's end, 2 more witnesses have testified. The stage is now meticulously set. Bugliosi intends to call his main witness first thing Monday morning. Manson, having heard Bugliosi's opening statement, must have realized the prosecutor had his number. That afternoon, as Sergeant William Maupin escorts Manson from the lockup, Manson makes his move. He tells Maupin it would be worth $100,000 to be set free, that money meant nothing to him, that an officer would only get a 6-month sentence if caught. A bribe attempt. Maupin reports it. Judge Older is informed. Bugliosi reads the report, wondering, what on earth would Manson try next? The answer comes swiftly. Over the weekend, Susan Atkins, Patricia Krenwinkel, and Leslie Van Houten follow their leader's earlier example. They heat bobby pins red hot and burn X's into their own foreheads, ripping the flesh open with needles for more prominent scars. Monday morning, the jurors file in, and the first thing they see are those 3 fresh raw X's. Graphic, undeniable proof. When Manson led, the girls followed. A day or so later, other family members, Sandy, Squeaky, Gypsy, do the same. It becomes a ritual, complete chillingly, to tasting the blood as it runs down their faces. The battle lines are drawn. The prosecution has laid out a motive so outlandish it's almost unbelievable, yet so tied to the evidence it's terrifyingly plausible. And Manson's influence, even from behind bars, remains potent, his mark literally spreading. The trial has only just begun, but the shadow of Helter Skelter and the diabolical mind of Charles Manson already looms impossibly large. What will Linda Kasabian reveal? Can Bugliosi truly prove such a bizarre motive beyond all doubt? Join us after this quick break as the trial of the century continues to unfold. The Tate LaBianca murder trial is underway, and prosecutor Vincent Bugliosi has just laid out the prosecution's shocking theory. Charles Manson, driven by a bizarre prophecy of a race war he dubbed Helter Skelter, orchestrated these horrific crimes. Now the moment has arrived for the prosecution's star witness to take the stand. A woman who was there, a woman who participated, and a woman whose testimony could seal Manson's fate, Linda Kasabian. The journey from Sybil Brand Women's Prison to the Hall of Justice was a gauntlet for Linda. 8 sheriff's deputies escorted her, taking an entrance designed to bypass the ever-present Manson family members, but they couldn't avoid everyone. On the 9th floor, Sandra Good, one of Manson's most fervent devotees, suddenly materialized in the corridor, her voice shrill and accusing, "You'll kill us all! You'll kill us all!" Witnesses said Linda, rather than shaken, seemed more sad. Bugliosi saw Linda shortly after her arrival. Her attorney, Gary Fleischman, had bought her a new dress for this crucial appearance, but it had been misplaced. She was wearing the same maternity dress she'd worn when pregnant, a baggy tent that ironically made her look more stereotypically hippie than the defendants themselves. Bugliosi quickly explained the situation to Judge Older, who graciously delayed proceedings until the new dress was found. A small courtesy, but a moment of calm before the storm. Later, the same consideration would be extended to Susan Atkins when she, of all things, lost her bra. Finally, the courtroom settled. Bugliosi stood. The people call Linda Kasabian. As Linda walked to the stand, the contrast was stark. Her expression was one of sadness and resignation as she looked towards Manson and the 3 female defendants. Their glares in return were pure, unadulterated hostility. The clerk moved to swear her in. "Would you raise your right hand, please?" Before Linda could even respond, Irving Kanarek, Manson's lawyer, was on his feet, his voice ringing out, "Object, Your Honor, on the grounds this witness is not competent and she is insane." Bugliosi was instantly up. "Wait a minute. Your Honor, I move to strike that, and I ask the court to find him in contempt for gross misconduct." This is unbelievable on his part. Unbelievable, perhaps, but for those familiar with Kanarek's courtroom style, it was depressingly predictable. This was exactly the kind of disruptive tactic they had feared. Judge Older ordered the jury to disregard Kanarek's outburst and summoned the lawyers to the bench. "There is no question about it," Older told Kanarek sternly. "Your conduct is outrageous." Bugliosi, frustrated, voiced his concerns. "I know the court cannot prevent him from speaking up, but God knows what he is going to say in the future. If I were to say something like this in open court, I would probably be thrown off the case by my office and disbarred." Paul Fitzgerald, another defense attorney, defended Kanarek, stating their intention to call witnesses who would testify that Linda Kasabian had taken LSD at least 300 times, rendering her, in their view, mentally incapable. Judge Older was unmoved by the justification for the outburst. Matters of law, he warned, were for the bench or chambers, not for jury theatrics. He issued a stern warning to Kanarek. One more outburst like that, and there would be consequences. Linda was finally sworn in. Bugliosi began, carefully. "Linda, you realize that you are presently charged with 7 counts of murder and 1 count of conspiracy to commit murder?" "Yes," she replied. Kanarek objected. Motion for a mistrial. Denied. It took a full 10 minutes for Bugliosi to get to his second question, establishing Linda's awareness of the immunity deal. Testify truthfully about everything she knew, and the district attorney's office would petition for all charges against her to be dismissed. Yes, I am aware, Linda confirmed. Kanarek objected again on 4 different grounds, all denied. By addressing the immunity deal up front, Bugliosi aimed to defuse one of the defense's biggest weapons. Besides the benefits which will accrue to you under the agreement, Bugliosi asked, is there any other reason why you have decided to tell everything you know about these 7 murders? After another barrage of objections, Linda's quiet answer cut through. I strongly believe in the truth, and I feel the truth should be spoken. The interruptions were relentless. Kanarek even objected to Bugliosi asking Linda how many children she had. He often employed what Bugliosi thought of as a shotgun approach, rattling off objections like leading and suggestive, no foundation, conclusion, and hearsay, hoping something would stick, even if the grounds were laughably inapplicable. It was a tactic Bugliosi had anticipated, so it didn't faze him personally. But it was effective in one way. It took over an hour of this legal trench warfare just to get Linda to the point of her first meeting with Manson, her description of life at Spahn Ranch, and over Kanarek's predictably heated objections, her definition of the family. Well, Linda explained, we lived together as one family. As a family lives together as a mother and father and children, but we were all just one. But Charlie was the head. Then a serious snag. As Bugliosi questioned Linda about Manson's orders to the girls, Judge Older unexpectedly began sustaining Kanarek's hearsay objections. Bugliosi asked to approach the bench. This was critical. If statements about Manson's directions to his followers were ruled inadmissible hearsay, the entire framework of Manson's domination, the core of the prosecution's case against him, would crumble. Bugliosi, who prided himself on anticipating legal challenges, confessed to Judge Older, I never anticipated I'd have any trouble showing Manson's directions to members of the family. Older simply stated he couldn't think of an exception to the hearsay rule that would permit it. Court recessed for the day. Bugliosi, along with his colleagues Aaron Stovitz and J. Miller Levy, burned the midnight oil, frantically searching for legal precedents. Their efforts paid off. They found 2 cases, People v. Fratiano and People v. Stevens, which ruled that the existence of a conspiracy could indeed be shown by the relationship between the parties, including statements made to each other. The next morning, presented with these authorities, Judge Older reversed himself. The hearsay objections were overruled. The case against Manson was back on track. But then, opposition came from an entirely unexpected quarter. Bugliosi's own co-counsel, Aaron Stovitz. Linda was testifying about Manson ordering the girls to make love to male visitors to entice them into the family. Bugliosi asked, Linda, do you know what a sexual orgy is? Kanarek objected naturally, but so did another defense lawyer, Hughes, with a rather telling phrase, we are not trying the sex lives of these people. We are trying the murder lives of these people. As defense attorneys shouted, Stovitz leaned over to Bugliosi, whispering, can't we skip this stuff? We're just wasting time. Let's get into the 2 nights of murder. Bugliosi, already battling the judge and Kanarek, was firm. Look, Aaron, he whispered back. I'm fighting the judge, I'm fighting Kanarek. I'm not going to fight you. This is important, and I'm going to get it in. And get it in he did. Between Kanarek's constant interruptions, Linda testified that Manson decided when orgies would occur, who would participate, and the roles each person would play. He was, as Bugliosi put it, the maestro, orchestrating every detail. This wasn't about salaciousness. It was about control. That Manson dictated even this most intimate aspect of his followers' lives was powerful evidence of his absolute domination. Crucially, among those involved in one particular orgy Linda described were Tex Watson, Susan Atkins, Leslie Van Houten, and Patricia Krenwinkel, the very individuals accused of carrying out the murders. Once the point was made, Bugliosi moved on, guiding Linda's testimony to Helter Skelter, the Black-White War, Manson's belief that the Beatles were sending him messages, and his chilling announcement on the afternoon of August 8, 1969, now is the time for Helter Skelter. The Los Angeles Times noted Linda Kasabian's surprising demeanor on the stand. Serene, soft-spoken, even demure, even when discussing the group's sex life. Her testimony was also profoundly moving at times, especially when she described Manson separating mothers from their children and her own stolen moments of love with her daughter, Tanya, when there wasn't anybody around, especially Charlie. The tension in the courtroom was a living thing. As Linda described Manson's directions just before they left Spahn Ranch for the Tate residence, Charlie himself, seated at the counsel table, made a horrifying gesture. He put his hand to his neck and, with one finger extended, drew it across his throat in a slitting motion. Bugliosi didn't see it, but Linda did. Others did. Yet her voice didn't falter. She continued, detailing Tex Watson stopping the car, the cutting of the telephone wires, climbing the fence, then sudden headlights. "And a car pulled up in front of us," Linda testified, and Tex leaped forward with a gun in his hand. And the man said, "Please don't hurt me. I won't say anything." And Tex shot him 4 times. As she described the murder of young Stephen Parent, Linda began to sob, just as she had every time she'd recounted it to Bugliosi. The jury, he could tell, was visibly moved by the horror and by her raw emotion. In stark contrast, Susan Sadie Atkins giggled. Leslie Van Houten sketched. Patricia Katie Krenwinkel looked bored. By the end of that day, Bugliosi had guided Linda's testimony to the point where Katie Krenwinkel was chasing Abigail Folger with a knife and Tex Watson was repeatedly stabbing Wojtek Frykowski. "He just kept doing it and doing it and doing it," Linda whispered. When the man was screaming, Bugliosi asked, "Do you know what he was screaming?" Her answer was haunting. There were no words. It was beyond words. It was just screams. Reporters attempting to count Kanarek's objections gave up on the 3rd day. The count had soared past 200. Judge Older finally had enough. After Kanarek interrupted Linda mid-sentence yet again, directly violating a court order, Older declared, "Mr. Kanarek, you have directly violated my order. I find you in contempt of court, and I sentence you to 1 night in the county jail, starting immediately after this court adjourns." Kanarek's defense? Rather than my interrupting the witness interrupted me. Kanarek wouldn't be lonely in jail for long. Later, when Bugliosi attempted to introduce a photograph of a sword found in Manson's dune buggy, defense attorney Hughes charged, "The district attorney is withholding great quantities of evidence from us." Bugliosi calmly stated he'd only just seen the photo himself. Hughes shot back, "That is a lot of shit, Mr. Bugliosi." Judge Older immediately held Hughes in direct contempt. Given a choice between a $75 fine or a night in jail, Hughes, claiming to be a pauper, chose jail. Kanarek's night in the cells taught him nothing. The next morning he was right back to his disruptive tactics. Bugliosi, however, was usually able to work around sustained objections, rephrasing questions to get the testimony in. For instance, when Older blocked questions about the defendants watching news of the Tate murders, Bugliosi simply asked Linda when she first learned the victims' identities. "The following day on the news," she said. "On television?" "In Mr. Spahn's trailer?" "Yes." The relevance would become clear later, when another witness, Barbara Hoyt, would testify that Sadie had told her to turn on the news, that they never usually watched it, and that they left as soon as the Tate segment ended. Throughout Linda's testimony regarding the second night, the LaBianca murders, Bugliosi hammered one theme. Who gave the directions? Charlie. Did anyone question his commands? No. Her testimony was filled with a multitude of details only someone present at those horrendous slaughters could have known. Manson, realizing early on how damaging this was, had muttered, loud enough for Linda and the jury to hear, "You've already told 3 lies." Linda, looking directly at him, had replied with quiet strength, "Oh no, Charlie, I've spoken the truth and you know it." By the time Bugliosi finished his direct examination on the afternoon of July 30th, he had a strong feeling the jury knew it too. Bugliosi employed a key trial tactic, bringing out potentially damaging information himself. He'd already questioned Linda direct about her sexual history and drug use, so when the defense, particularly Paul Fitzgerald, Krenwinkel's lawyer, tried to use these points to destroy her credibility, they found themselves treading familiar ground. In fact, Their cross-examination sometimes strengthened the prosecution's case. It was Fitzgerald who elicited Linda's admission that during her time at Spawn, "I was not really together in myself. I was extremely impressionistic. I let others put ideas in me." And crucially, that she feared Manson. "What were you afraid of?" Fitzgerald asked. "I was just afraid," Linda said. "He was a heavy dude. He just had something, that could hold you. He was a heavy weight. He was just heavy, period." Fitzgerald also got Linda to admit she loved Manson, that she felt he was the Messiah come again. Then Linda offered a profound insight that helped explain her and others' devotion. When she first saw Manson, she said, "I thought, this is what I have been looking for, and this is what I saw in him." Manson, a mirror reflecting the desires of those who look to him. Fitzgerald's questions about Helter Skelter, Manson's racial views, and his domination only brought out more information bolstering Linda's previous testimony. Some questions backfired spectacularly, as when he asked who she slept with on certain nights. "No," she'd reply to specific dates, then add, "but eventually I slept with all the men." Her openness was disarming. Asked if she enjoyed an orgy, she answered frankly, "Yeah, I guess I did. I will have to say I did." By the end of Fitzgerald's cross-examination, Linda Kasabian, if anything, looked even more credible. It was Monday, August 3rd, 1970. Bugliosi was returning to court after lunch when a swarm of newsmen abruptly surrounded him, all talking at once. It took a moment for the words to cut through the cacophony. "Vince, have you heard the news? President Nixon just said that Manson's guilty." The President of the United States declaring Charles Manson guilty in the middle of his trial. How could this unprecedented statement affect the proceedings? What impact would it have on the jury, on the defense, and on the pursuit of justice? The Manson trial, already a circus of the bizarre and the horrific, had just been thrown a political hand grenade. Join us next time on Crime Time Inc. as the shockwaves of Nixon's declaration hit the courtroom. But after this quick break, Scotland's own version of Don Rickles and Buddy Hackett will give us their thoughts on this episode.
Thank you, Alec. Another fantastic episode 21 now, Tom. There's so much detail in these episodes that it's a tricky job just to pick out a few that are worthy of talking about. I mean, it's all worthy of talking about. Just a few is tricky. The highlights, if you like. The first thing I picked up here was this principle of the grand jury that they have in the States. That's probably familiar to our listeners because they hear it, but not familiar really how it works or why it works. I love these courtroom things. I love John Grisham books and I love all the TV dramas. You'll go back to Perry Mason and whatnot. Of course, you'll have your own favourites from a different era. I think it's worth explaining the purpose of the grand jury because it comes between. We submit a case, the police submit a case to the Crown, to the Procurator Fiscal, who then determines whether it's going to go ahead or not, whether there's going to be an indictment issued, whether the accused is going to appear in court to answer for these charges. But this is between that. This is something that the Crown do before they decide to take a prosecution. They take it to a grand jury. It was very interesting, wasn't it?
It was, and you're right. I thought I knew about the grand jury, what it did, but Alex, you've done a super job. But before we go any further, can I say, Alex, thank you very much for the compliment. You actually compared me to Don Rickles. Don Rickles was one of my favourite comedians, so thank you for that, Alex. I consider that to be a high compliment. But to be serious, yes, the grand jury, very interesting because we think that our legal systems are comparable. And of course, the legal system in the United States of America is based on the British legal system. But the grand jury is different. The grand jury, as you say, comes in between like a sandwich and decides whether an indictment will be handed down. Now, in our system, that's the Lord Advocate and the Procurator's Fiscal operating for him. So very, very different. And of course, incredibly powerful because they literally decide whether the case goes forward or not. So it was very, very interesting and another great episode. Like you, I'm fascinated by courtroom drama. I can't calculate how long I have spent of my life sitting in courts and witness waiting rooms more than the body of the courts. But I love courtroom drama. And it's one of the things that we don't do well now in TV. Now, you don't see as many courtroom dramas. And yeah, I think Perry Mason was great.
I knew you'd like him. The interesting thing for me, it was between 16 and 23 people sit on the grand jury. It's not a fixed number, Tom. And it's held in secret, totally in secret. There's no judge. There's no lawyers generally. It's just the advocate, that we would call it, and a jury. And he's presenting the evidence himself and calling witnesses to show them that he's got enough to move forward. It's quite a safeguard, isn't it?
Yes, it is a safeguard, and it's also a very important role for the public in their justice system. It's one of the things I always say about this move. Thankfully, it's been put in the back burner now to remove juries from trials in Scotland, because juries are one of the main ways we, the public, participate in our justice system. Therefore, I think it's very important that be continued.
Was Rumpole a favourite of yours, Tom?
I used to be driving in the afternoon places, and there was a Rumpole of the Bailey on the car radio,
Yeah.
and it was fantastic. Like a lot of things like this, you actually get a lot more quality from the radio than sometimes you do from the television, I think. So
Yes.
yeah, I enjoyed Rumpole. And of course, that was written by a man who had been a silk English system. So yeah, I did enjoy it.
Superb. So the trial itself, Tom, the judge is he's under protection because of threats that he's getting. And the Americans treat things like that differently, don't they? They love to tell you when someone's under protection. Most of the protection work I ever did, nobody ever knew that they were under protection. It was a bit more discreet.
No, that was the point. But I suppose in America, it's interesting, isn't it? I don't know if you saw about the witness, the guy Dennis, who was getting drive-bys and threatened by the family. Manson's family are very much still there. There's a sort of a visible, aggressive presence harassing witnesses. But I've seen it, and you've seen it too sometimes, Simon. It can backfire because witnesses who are harassed sometimes say, hang on a minute, I'm not going to stand this. You're threatening me. I'll tell you what I'll do. I'm going to phone the police. Sometimes it works against them. And that's what happened in this case.
I was going to come to that, Tom, that everything that Manson, the whole way he conducted himself and the way his family conducted themselves outside the court and all the rest of it, starting off with the X in his forehead. Overnight, he carves this X in his forehead, and the family copy him in doing that thereafter. None of that stuff did his case any good, did it?
No, but I mean, the thing is, none of it has been very clever, Simon. None of it's been very clever. But you see, if you are guided by some messianic purpose, if you truly believe that you are the second coming of Jesus Christ, it didn't have to be clever. They made little attempt to cover up evidence. It was, frankly, only the incompetence of our colleagues over there that there wasn't a Stonewall case. It was left to Bugliosi to discover all these pieces of evidence. But it's not because they weren't left. They were. I mean, they threw their clothes away, they dumped the gun, they did everything that they shouldn't have done, left plenty of evidence. So none of it's been clever. Yeah.
Let me ask you a question. And hindsight's always great when we're talking 60 years later almost. Mm-hmm. If Manson had turned up for his trial with a proper solicitor, and we'll come on to him in a minute or two, his lawyer, he's a cracker. If he turned up with a proper defence team, got his hair cut maybe, and put a suit on, and had played the game, i.e. had tried to appear normal in front of the jury, had tried to appear like some kind of victim, and had disowned this family and made them responsible for everything, because after all, as far as we know, he never killed anyone. Do you think we could have had a completely different outcome, given that we're trying to prove his culpability simply in motivating people to go and commit horrific acts? I can hardly think of a harder crime to prosecute and get a conviction on. Do you think if he'd played it differently, it could have worked?
Yes, I do. I think because he wasn't at the crime scene of the Tate or the LaBianca murders. He wasn't at the crime scene then. So yes, I think he could have got away with it, he'd done that. But that would have gone against the whole grain of his being, because the trial for him is a performance. It's a chance for him to be centre stage. It is a role he wishes to play out. He could no more have dressed in a suit and tie and looked contrite than fly in the air, because that would have flown against everything that Charlie Manson was. So the trial was always going to be a circus, not just because of Kanarak, the lawyer he chose, who is a real cracker. And it was funny, I was laughing because I've known some really obstructive, horrific defence lawyers, but nothing in that league. I'm really pleased he wasn't operating in Scotland. But he himself, he was always going to be a three-ring circus because of he himself. And this self-disfigurement is only one part of that performance.
Interesting, isn't it? Because he's never been trite at all. He's never shown any remorse or anything like that. It never did.
I was wondering, Simon, I haven't heard Alex refer to it. Has Manson ever been psychiatrically assessed? I don't know if he has. Has he ever been? And that's the other thing. He could have said that he was unfit, and he could have cited his violent upbringing. He could have cited his drug use. He could have cited all sorts of things as a get-out clause. And he never did.
Bugliosi gave him an out because when he did his opening speech, he called him a megalomaniac. So when the word maniac's there already, you'd think there's an obvious route to go down, either insanity. I don't know what the legal terms would be in the States, but over here it would be either insanity at the time of the crimes or insanity at the time of the trial. And I think Charlie could have gone for both counts, actually.
Well, certainly would have been worth a try. But once again, as we've said, that would have flown in the face of his super ego. I'm not sure whether he was a megalomaniac, but certainly his enormous sense of self-importance and his role as being the second coming and all the rest. It's a very good question of whether or not he may have been able to walk on the basis of being unfit to plead on the basis of mental instability. But we'll ask that, Alex. Alex, about that. That's interesting.
Because it's standing out like a sore thumb, isn't it? The mental health of the guy and his followers, of course. There was so much in this episode. The delivery of the bike, Chance comes into it as well, and the police again failing to grasp the importance of it at the time. But the one thing I wanted to bring out that I don't think we've spoke about here on Crime Time Inc. about forensics was tools. We used to call it tools when we were training and when we were using it in examinations. This was the cutting of the telephone cables at the Tate House. The tool used to do that was recovered at the Farm. And that's an interesting part of forensic, isn't it? Screwdrivers, wrenches, all sorts of tools that are used by criminals when they're discovered. I know that they're not as good as a fingerprint, but it's like a footprint. Sometimes it's very good evidence as part of your case in court.
Oh, that's right. And the thing is, Simon, remember, in pre-DNA days, tool marks, footprints, tiny little things like that, they were all the supporting parts of forensic evidence. I'm not sure whether our forensic examiners now have not heard about the old expertise in these parts of physical evidence, the tying of knots, things like that. I'm not sure whether that still exists, or I'm not sure whether it is still prioritised the way it was before DNA. But the other thing about this episode that absolutely stopped me in my tracks was the intervention of Richard Nixon. What is going on? Clearly, he must have said that. It just shows how it worked or didn't work in the White House under Nixon, because usually everything that comes out of the mouth of a president of the United States is scripted, checked, and is passed by various people and scriptwriters. I've just finished watching a fascinating, really very good, thoroughly recommend it, a three-part piece on the hunt for bin Laden. And at the very end, once they have killed bin Laden, it's how they announce it. And you see them preparing President Obama's speech. And all he was saying is, we've captured and killed Osama bin Laden. That's literally what he was saying. But it was all carefully scripted and checked by the Attorney General. It was checked and that one, all this. Nothing was done just off the cuff. And here is Nixon, potentially destroying the case by saying, oh, well, he's guilty. I always thought Nixon, well, tricky dicky, I always thought he was an unprincipled man, but I never thought he was a stupid man. I thought Nixon was stupid. But this...
It's something you could imagine Trump saying, isn't it?
Yes.
Just off the cuff.
He's a guy that shoots from the hip. But I didn't think that Nixon did. I
No.
thought Nixon was a schemer, a planner, a calculator.
Yeah.
Just the opposite of that. Nixon was a lawyer. I mean, he was
Goodness sake.
actually a lawyer. He might have done civil law, or he might have done property,
Yeah.
or corporate law, I don't know, but he would have known that.
Tom, you mentioned the psychiatrics of Charles Manson, so I messaged Alec, and he must be up at this time because he's replied to me. Do you want to hear what he's replied?
Yeah.
Yes, Charles Manson underwent multiple psychiatric assessments throughout his life, both during his youth and during his trial for the Tate LaBianca murders.
Right.
Early assessments. Manson was first subjected to psychiatric evaluation as a child and teenager. Some of the assessments included at age 13 at the Indiana Boys School. During the trial in 1970, he underwent court-ordered psychiatric evaluations. No formal diagnosis of insanity was made, despite his bizarre courtroom behaviour, the carving in his forehead and all that. And psychiatrists described him as having sociopathic or psychopathic tendencies, paranoid delusions, and a strong need for control and domination. He was declared competent to stand trial and to represent himself, though the court later reversed the self-representation decision due to his erratic behaviour. But about later years as well, when he continued to exhibit behaviour consistent with antisocial personality disorder and narcissistic personality disorder, and some prison staff speculated about possible schizophrenia or delusional disorder, but that was never formally diagnosed. Interesting.
That's right. That clears up a lot. So thanks, Alex. Sorry, get you out of your bed, my boy. But that does clear up a lot, doesn't it? What they're actually saying, Simon, is that yes, he exhibited all of these things, but actually deep down he still knew what he was doing.
Good, Tom. Yeah. The only other thing from that episode that I think you've mentioned already was Kanarek, the solicitor. I always found it very annoying, as the whole court did, when you got lawyers like that. And I used to get it in Rothsay Court a lot because they thought in Dunoon and Campbelltown, because you got city lawyers coming down to these places and thinking they were big shots. They would soon get shot down, I can assure you, because a sheriff in a backwater like that is just as powerful as a sheriff in the Glasgow Sheriff Court or Edinburgh Sheriff Court. Do you know what I mean? So they get shot down, and I always thought, especially in front of a jury, because it's a performance in front of a jury that everybody's putting on, including us. I always thought that they did themselves no good in front of a jury. If everybody else kept straight-laced and kept things as they should be, they looked kind of foolish in front of the jury. They could see right through their antics.
We had one particularly annoying solicitor who used to plague the Sheriff Summary Court. I often wondered about the wisdom, and in fact I spoke to a couple of guys who he represented. I said, what do you actually want to do here? Are you wanting to become the centre of a stage in some sort of comedy act, or do you want to get off? If you want to be found not guilty or get the benefit of the doubt of the court, and you're absolutely right about the sheriffs, I think actually in the county areas down where you were, the sheriffs were actually even more powerful. Because the thing was that if you appeared before the court, you would always appear before that sheriff. It was his court. Whereas in Edinburgh or Glasgow, you might get lucky and appear in front of another sheriff. I used to say, do you actually want the sympathy of the court, i.e. the sympathy of the sheriff? Because some solicitors, when they came in, you could almost see the sheriff's lip curling as they came in.
There's a story with Irvin Smith, who lived in Rothsay in the Isle of Bute. He used to cover Greenock Sheriff Court. He would go over every morning to Greenock Sheriff Court, and he was detested, absolutely detested by the criminals in Greenock. I don't know if you've ever been in Greenock Sheriff Court. It's got a big board at the entrance just as you go in the hallway, and it's got each court on it and the sheriff that's sitting in each court that day. And Irvin told me a story that he went over early in the morning because the forecast was poor, so he had to get the Rothsay ferry, and he got it over very early and was there sharp, went for his breakfast and then went to the court. As he was walking into the court, Tom, his story, remember, he sees all these wee guys lined up looking to see what sheriff they've got, and somebody says, "Oh no, Irvin Smith's here. He must be able to walk in water as well." That was Irvin telling that story.
Yeah, he was a fantastic after-dinner speaker.
Yeah.
I had him speaking a couple of times. He was a great character. I once saw a famous, and it was an armed robbery. I maybe told you the story before. I don't. It was an armed robbery, and the evidence was good, but it could have been better. However, Nicholas Fairbairn, who had been the Solicitor General, of course, and was a flamboyant and some would say head speckle character. He was appearing for the defence, and on the bench was Lord Wheatley, the Lord Justice Clerk. And Wheatley clearly, that's Lord Wheatley Senior, Wheatley clearly despised Fairbairn because of the disgrace he'd brought upon the legal profession. If you recall, Fairbairn had fallen from grace, he'd been sacked, there was an incident where somebody attempted to commit suicide out of his house and all that. There was all sorts of things attached to Nicky Fairbairn and his lifestyle. And you could hear the sarcasm dripping from Wheatley. When I saw that lineup, I thought, well, that, put it this way, if there was any benefit of the doubt to be given, let me make it clear, Lord Wheatley Senior was one of the finest judges of the 20th century, in my view. He was a magnificent judge, fabulous judge, and did a lot outside the legal profession. You could just see from his body language and the way he was looking at Fairbairn. Oh, dear.
Brilliant.
Yeah.
You don't fall out with the referee, it's basic, isn't it? So, Tom, not only was the judge under protection here, but this was a long time for the jury to be put away, weren't they? They were put away into the famous Ambassador Hotel for the duration of the trial, just as well, because they couldn't see the press and what was going on with Nixon and whatnot in the outside world. Although Manson's lawyer tried to pull a flanker by showing them the newspaper in the court, which was a bit naughty, wasn't it?
Yeah. Isn't it interesting in these cases we do, there are things that keep repeating. The Ambassador Hotel, a very famous venue, of course, for something completely different, for what took place in the ballroom there. The killing of Bobby Kennedy, the shooting of Bobby Kennedy. We've covered that in Crime Time Inc. I really remember the episode. Was it Series 3?
It was episode 108 off the top of my head.
Isn't it interesting how these things keep cross-referencing? This case has been fascinating for that. We've had walk-on parts from pop stars and celebrities and you name it. That always interests me when I see these lines crossing.
Tom, fascinating episode, and we continue with it into episode 22. It's gathering pace now, isn't it?
It really is. The trial has become, as I say, a three-ring circus. And that, of course, is a risk. That's a risk for the prosecution. It's possible the jury becomes distracted. 12 people in the jury, interestingly. The English number, not the Scottish number, 15. So there's all sorts of risks attached to distraction in a trial. And there were so many distractions here, not just by Charlie himself, but also by the solicitor Canarak and the other solicitors, because there's a whole raft of solicitors who themselves are getting into trouble. They're defending some of the family, some of the girls, and they themselves are getting into trouble.
Tom, we've been reluctant to have a go at the police too much, like we always are on here, because it's easy with hindsight and years between us and all the rest of it. It's easy to double guess. But the carry on with the bike was astonishing, wasn't it? And it was a very important part of the case because it was the last person to see anyone alive at the Tate household. Was the bike being delivered? What did you make of that story?
I know. It's just another, throughout this whole thing, I've been frustrated by this thing because you can't help but feel that had there been a decent murder squad put on this, that all of these things would have been picked up. How often have you been involved in a murder squad and there's very little to go on, just a body found lying, there's very little to go on. Here, there's so much evidence lying around. It's just incredible. But again, it's the coincidences that get me out of the bike shop and all the famous customers in this Hollywood bike shop, including the famous Snozzle Durante, who I've always thought, Simon, bore a little bit of a resemblance to yourself.
Yeah, I think if I had the piano, and I think so. I think you're right. Cinema piano.
That's very good. That's very good.
He was good.
Yeah, he was a great actor. But the other thing that struck me was how close people come. And we've seen this before in our police service, that if you're just standing in the wrong place at the wrong time, you become the victim of some terrible accident or crime. And I was thinking about that young courting couple who were all set to go up into Cielo Drive to the dark, secluded spot in the car and do a bit of canoodling in the car.
Yeah.
And they'd have almost certainly been dead because they were right in the path of this murderous group of people that arrived to kill Sharon Tate and the other guests. So there you go, the fickle finger of fate.
Mm-hmm. Tom, the thing was what would have been a witness, not just speaking to the last person, to see these people alive, very, very important, and what was said, the demeanour, the circumstances, everything that was going on round about. But the timeline, very important too. And it's the first thing we always try to establish with an inquiry is the timeline of events, isn't it? And that's where the witness statements come in, trying to piece them into this chronological order of events that very often, when you see it, it starts to stick out to you what the important parts are. In fact, when we take a crime report, it's one of the first things that we always ask, or we used to, I'm talking about the old days, is to establish between what times this crime occurred. You went to bed at 11:47 when the news came on, and you got up at 6:42, and that's when the crime occurred. And that helps narrow down the inquiry as well.
It does, and it also is very handy for the pathologist as well to give them a time frame, to say that the last person to see this alive was at midnight, who was definitely alive at midnight. And also it forms a kind of corroboration as well, because if the pathologist said, well, he'd been dead for 14 hours, which meant that he died between 2 a.m. and 4 a.m. or died between 2 a.m. and 6 a.m. in the morning, and you've got a witness speaking to him being alive at midnight, then you've got a window there. You're starting to close the parameters down a little bit. So even whether it's a suspicious death, whether it's just an ordinary sudden death, a non-suspicious death, you would still want to establish who the last person to see the deceased alive was. In fact, I'm sure, if my memory serves me right, we had a pro forma for non-suspicious sudden deaths, and I'm sure that was the last person to see the deceased, whether it was when the message was delivered last week or whatever. I'm sure that was something that we always tried to establish, let alone a scene of bloody murder, which this was. It would have been extraordinarily important to actually narrow down the angles. So once again, it's one of these incredibly basic things that wasn't done. And I come back to this business about, there was clearly nobody gripped it. There was no squad. There was no plan. I've spoken before on this podcast many times about having good people and good systems. They clearly they may have had good, I don't know how good the detectives were individually, but clearly the systems were wholly inadequate or absent altogether.
Yes. And it's something we'll find out later, I hope, is what changes were made in the LAPD after this because of this case, because it must have highlighted a lot of those problems in Los Angeles at the time.
That is the thing that interests me most. What was the learning from this? Did it change things a lot? Was it a turning point? Was it used positively to bring about positive change? Sometimes these things do, and sometimes they don't, and it'll be very interesting to find out.
Good. Lots to look forward to. Look forward to episode 22. Speak soon.